Our next chapter in instructional techniques for company officers will be chapter 2, and this chapter covers all of our legal issues. So we'll start out with our objectives. For instructor 1, 2, and 3, we'll have the same objectives, and then we will add just a few in each case. And with instructor 1, we want to talk about the laws and standards, how they apply to the fire service instructor, and then the importance of proper record keeping. Also, the ability to apply those laws and standards to instructional delivery. With instructor level 2, again, we will apply how the laws and standards apply as an instructor, the importance of the record keeping, and we'll describe the records and reports required by the fire department. And also the ability to apply laws and standards to the instructional delivery at the instructor 2 level. And with instructor 3, it'll be all these things, and we'll also demonstrate the ability to apply the laws at the instructional delivery level, as well as with each level of instructor. So every training session exposes us as instructors and fire departments to potential liabilities. To reduce the exposure to liability, we got to have the knowledge of the law. We also need to know the applicable standards, the standard operating guidelines, and also the department's rules and regulations. Statutes, we know that are legislative process, federal and or state. Regulations or codes are administrative or local level processes. So statutes, again, created by legislative action and embody the law, basically the law of the land, if you will, at both the federal and state levels. Examples are the Americans with Disability Act, motor vehicle code, so on and so forth. Codes regulations can be established by legislative action, but are most commonly created by an administrative agency or a local entity with the authority to do so. Codes and regulations usually deal with narrower issues and then enhance existing laws that are in place. The NFPA, or the National Fire Protection Association, codes and building codes are the most thought of as this example. And then we come to standards, which is any rule, guideline, or practice recognized as being established by an authority or common usage. Standards take on the effect of law if they are adopted by a local entity. Again, NFPA standards, Occupational Safety and Health Administration standards are examples of these. So the law as it applies to us as fire instructors. Instructors' conduct is governed by 3 sources of law. Again, federal law, statutory law, and or state law, which we know, again, state law is established by your state legislature. Policies and procedures, which are crafted by individual fire departments, SOPs and those guidelines. Federal law versus departmental policies and procedures. Federal law and state laws apply to all citizens, and in which is a standard all instructors are measured. Policies and procedures are specific to a particular fire department. They may vary from region to region, and they must not violate any state or federal law. Policies and procedures for your department can place obligations upon an instructor that are not required by federal and or state laws. They're designed specifically for more individual department and professionals who work within it. Instructors must be well versed in the policies and procedures of their particular fire department. And a lot of times these policies and procedures are often modeled by or of the NFPA standards. National guidelines, again, the National Fire Protection Agency, not legally binding, it sets out a consensus of fire service across the United States and is used to judge questionable conduct. So although it's not legally binding unless a locality were to vote in and accept it as an ordinance, these guidelines are the consensus for the fire service across America. Basically, this is how the fire service and what the fire service should be doing and how they handle certain things. So what's our responsibility as fire instructors? We have an immense responsibility to conduct, manage, and administer our training programs. The potential for liability in the event that an injury or an accident occurs, or even a fatality, and even a lawsuit. Instructors must be aware of the laws that pertain to each level of instructor responsibility. All levels of instructor will have different applications of statutes and laws in the performance of their duties. Continuing professional development is necessary to review trends and to keep up to date on cases and judgments for and against a fire department and its training programs. So that brings us to record keeping. We've talked about record keeping and we know how important that it is across the board, but this is one of the things that can insulate you and your fire department from potential liability. This affords some level of protection. Inadequate or incomplete records may increase liability. So on our rosters and our records where it states and it has room to document the type of training, whether or not you did skills, to attach those skill sheets, what curriculum did you use and did you go by. The documentation of all those things puts provability on the type of instruction that you have delivered. Proper and thorough record keeping is your first line defense against liability. And this is in the real world, this is your first line defense when it comes to making runs, EMS runs, fire runs, doesn't matter. And this is going to be one of our first line defense against liability as an instructor. So we create and we maintain reports, records, and memoranda and emails. These should be organized appropriately and then maintained for a reasonable period of time in accordance with the local law. Some training records are required or should be kept for a lot lengthier period of time. The process of record keeping, this starts at the outset of each activity. What is the purpose of the training, the activities to be formed during a training, what equipment is to be used, and what are the goals and objectives of that training. Have available any sources used during the creation of these records. Confirm that training complies with policies and procedures. And this is one of the things that once we get together and we decide, hey, these are the objectives we're going to cover, this is the class curriculum, this is what we're going to use, we want to make sure that we put any policies and procedures into thought and make sure that we comply with those. We want to obtain documentation for firefighters from other departments. Enter into a hold harmless and indemnification agreement with any other department or agency involved. We get waiver forms, we sign release of liability. A lot of times when we do live fire training evolutions and we involve other departments in that training, and oftentimes we may share recruit class, especially if you're a department that has lower number of hirees in the recruit status. A lot of times we'll combine those classes and we'll enter into those agreements. We want to verify that all outside participants are medically cleared to participate. And if in part of the process, if we are part of that medical clearance as far as taking blood pressures prior to certain evolutions as an example, then we may be that component that keeps somebody from participating, but certainly they should have documentation of their physical and those things needed to medically clear them for their training. Off-site training, we need to inspect the site. Training should not violate any laws or create risks. We want to document each conversation and the steps that you take after the conversations. Sometimes we get properties that are donated for live burn evolutions. An example would be the house that somebody has that they want destroyed, and they decide that they want to donate this for the use of the fire department. There is a lot of documentation that goes on with this, not only the risk analysis, as most of these sites are off-site type training. We have to inspect it. We have to make sure that we're not going to violate any laws of easement, things like that. And then we want to document the conversations and have proof of the agreements with the property owners. Federal employment laws, specifically the Americans with Disabilities Act, or ADA, this prohibits discrimination against a qualified person because of a disability. Discrimination may include hiring, firing, promotions, and compensation. Also, the Civil Rights Act of 1964 prohibits discrimination based on your race, sex, or national origin. And then your Title IX of the Civil Rights Act in 1964 again prohibits discrimination that creates a hostile work environment. And this kind of goes along with the bully officer that wants to bully everyone around and that kind of thing. These are times that those things need to disappear from the fire service. Age Discrimination in Employment Act, the ADEA, this prohibits discrimination against persons older than 40 unless there is a qualification requirement. And this is a question that we get often. There are fire departments or there are cities that do enact this qualification requirement, and it can be under 40. A lot of them are anywhere from 36 to 40 years of age as far as initial employment will be the cutoff. And this is certainly the way this is done is legal. It doesn't pertain under the age discrimination. Equal Pay Act requires that all persons, regardless of gender, be paid the same rate when performing the same job. We'll start with the Americans with Disability Act. This protects individuals with disabilities from discrimination in the workplace. And a disability is a physical or mental impairment that substantially limits one or more major life activity. Also, a disability definition was expanded in 2008, and this determining whether an impairment substantially limits a major life activity should not take into account possible mitigating measures that include medication, medical supplies, prosthetics, and hearing aids. And there's a few of these that we recognize on a daily basis. Hearing aids is one that, in the fire service, being around loud pumps and fire apparatus throughout the years, can diminish and damage our hearing, especially if we were unable to use or did not use hearing protection. And you'll find firefighters out there that have hearing aids, as long as everything follows the NFPA standards on that. Uh, and that's one example out of many. Major life activities, examples: caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, or working. The employee must be restricted in the ability to perform a class of jobs or a broad range of jobs. It is not enough to say that an employee is unable to perform one particular job. Disabilities, conditions that may now be considered a disability: compulsive gambling, kleptomania, pyromania, current illegal use of drugs, and we must note that an impairment that is episodic or on remission is considered a disability if it would limit a major life activity when active. The two-step analysis: if an individual alleges a disability, then determine whether a disability exists. If yes, then we determine whether the disability can be reasonably accommodated. What do we mean with reasonable accommodation? Basically, this is a modification and or an adjustment that enables individual with a disability to perform the essential functions or tasks of the job, enjoy the benefits and privileges of employment, but does not create an undue hardship for the employer. So undue hardship exists if accommodation would require significant difficulty or expense relative to size, to available resources, and nature to the employer. Accommodation does not have to be provided if it would present a direct threat to health or security of others. Direct threat: 4 factors: the duration of the risk, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of potential harm itself. ADA in practice: be aware of ADA requirements, personnel who qualify for reasonable accommodation. If accommodation is requested, evaluate that request. If needed, contact higher authority and document the decision immediately. Prohibits employment discrimination based on race, color, religion, sex, or national origin. The discrimination does not have to be intentional. This applies to state and local units of government with 15 or more employees. If you witness the conduct, take corrective steps immediately. Follow procedures that are set by policy or agreements. Document the event and include witness statements. Complete your documentation as soon as possible. If you did not witness the conduct, follow the steps in the department's harassment policy. If responsible for investigating claims, begin investigation and document all relevant information. And this can be as simple as you begin your investigation, you find out what happened, find out the complaint, take notes as you interview each person with the relevant information. If you did not witness the conduct, again, if somebody else is responsible for investigating the incident, prepare a report that documents the information provided by the complainant, and then forward your report to the appropriate parties, and then follow up with the complaint. There are times that you may begin this process, you may even do an initial investigation, and then at some point it needs to go higher. Then you're going to forward that information on to the next level. Race and color harassment. This includes ethnic slurs, jokes, and derogatory or offensive comments based on a person's race or color. This creates an intimidating, hostile, or offensive type work environment, and it interferes with a person's ability and work performance. Religious discrimination also can be harassing slurs, jokes, and derogatory or offensive comments. May arise based on the scheduling of training classes. Sometimes this doesn't come, it's not, the information is not available to us when initial scheduling. We don't know that it's interfered with someone's religion, and those are the things that we have to try to work around. Sexual harassment, sexual advances, requests for sexual favors, and verbal physical conduct of a sexual nature affects employment, interferes with job performance, and it creates intimidating, hostile, and often an offensive work environments. And this includes discrimination based on pregnancy as well. Quid pro quo sexual harassment, usually in a supervisor subordinate type relationship. One party controls the other's future, if you will, or could control parts of their job and what they're asked to do. And it ties employment decisions to submission to or rejection of some form of sexual conduct. So if you do this, I'll do this for you, you do this for me type situation. Hostile work environment consists of inappropriate conduct between coworkers who do not have power to affect a person's job. Usually a pattern of behavior, can be sexual in nature, and interferes with the employee's work performance. A few misconceptions about sexual harassment. One is a victim has to be of the opposite sex from the alleged harasser. Obviously not true. The harasser must be an employee of the fire department and the victim's supervisors. Again, individuals not employed by the fire department can also create a hostile environment. Only the person who is object of the behavior can be harassed. Basically, anybody affected, including even bystanders, can be affected and make the claim. So taking action to constitute harassment conduct must be unwelcome. If you witness a violation or you receive a hostile environment complaint, you must try to rectify the situation. Taking no action at all or ignoring a complaint could expose the department and yourself to liability. National origin harassment, ethnic slurs, or other verbal or physical conduct based on a person's nationality, English only rules and so on and so forth. Anti-discrimination policies are policies set in place to ensure department has a policy prohibiting discrimination in the workplace. Department members should be given a copy of the policy, read, sign, and acknowledge of receipt, and sign commitment to abide by the policy. They should provide annual training on the policy and keep this policy, as with all policies, current and up to date. Let's talk about retaliation. Title VII prohibits retaliation for the filing a charge of discrimination, retaliation against participating in a discrimination investigation, and any retaliation otherwise opposing discrimination. The complainant and witness or witnesses must not be punished for reporting the misconduct. Section 1983 of the Civil Rights Act of 1964 allows complainant to sue department and alleged aggressor personally. Personal liability claim where alleged conduct falls outside scope of employment. The complainant can seek damages directly against the alleged aggressor and his or her assets. Punitive damages against an individual. Freedom of Information Act. The purpose of this act is to promote government accountability and the public's right to know. States have their own variation of the Freedom of Information Act. Generally, the Freedom of Information Act requests are made through designated public officials. Available records and information. The public is allowed access to the following documents. Could be administrative manuals and procedures, instructions to staff, substantive rules, statements and interpretations of policy, final planning policies, and factual reports such as inspection reports and records. State law may provide exemptions to the disclosure of certain documents. The government body may be required to redact personal information from certain documents as well. State record retention laws may dictate retention time of the public records. EEOC, or Equal Employment Opportunity Commission, is a federal agency that investigates and enforces federal laws pertaining to discrimination in the workplace, and it requires that employers take steps to prevent workplace discrimination. Can be accomplished through education of your department employees. Negligence, misfeasance, and malfeasance, two types of alleged wrongs in civil cases when an injury occurs. Unintentional conduct or accident, negligence, or misfeasance. The conduct that includes an element of intent or knowledge that a wrong is being committed then is known as malfeasance. So negligence and misfeasance, void of element of intent. So it does not have the element of intent. And based on a duty to prevent harm or injury to others, exercise degree of care commensurate with tasks being performed. Negligence exists when there is a breach of duty, so you have to have a duty to act. Then there is a breach of that duty owed to another. And then there has to be an injury, and the breach is proximate cause to that injury. Once these three elements are then established, you can become legally liable for your conduct. Basically, liability means responsibility. If a person or entity is found liable, the person or entity is responsible for paying for the damages may be caused by the actions or even inactions. Again, misfeasance is the most common in performance or otherwise lawful acts, and it consists of improper or wrongful performance of a lawful act without the intent through mistakes or carelessness. Immunity laws offer some protection to public employees for suits premised upon negligence or misfeasance, bar certain causes of action, or require a complainant to allege and substantiate a higher level of proof. Higher standard of proof requires that elements similar to intent be proved to prevail on the claim, requires proof of willful and wanton conduct or establishment of gross negligence, and allows public employees to work without fear that every mistake will expose them to liability. The willful and wanton conduct is an act that, if not intentional, shows utter indifference or conscious disregard for the safety of others. Gross negligence is an act or a failure to act that is so reckless that it shows a conscious voluntary disregard for safety rules, or safety of others. The facts of the incident. Does a particular act constitute willful and wanton conduct or gross negligence? The most common evidence that's considered departmental policies and procedures, one, and this is the reason why we need to know the departmental policies and procedures. And even if we're executing delivery at a different department as a guest, we need to know their policies and procedures that may pertain. Surrounding departments, policies, and procedures that we do mutual aid agreements and training with, as well as the training records and the national guidelines or standards such as NFPA standards. Malfeasance is more than a simple mistake or an accident. This is often associated with public officials who partake in unlawful conduct, usually results in criminal charges and could be a part of a civil suit as well. Next, let's talk about social media, and it's something that, of course, we're dealing with more and more today. And this is basically the line between public and private, and professional and social has become increasingly blurred. A lot of departments have now developed social media standards of operating procedures and guidelines. Social media usage has it's went up in recent years, which has in turn opened up a new area of potential liability. Basically, although you have freedom of speech and the right to say things in your opinion, you still have to be careful what you say when it comes to social media and in reflection to your job. So, what is social media? And examples of social media that we're dealing with today, probably the one on the forefront or the two on the forefront, Facebook, Twitter, and then we'll add in Instagram. I think MySpace is pretty well gone. I don't know of many people using it, but we also have Foursquare, Pinterest, Flickr. There are all sorts of blogs out there and a variety of other websites that can be considered and are considered social media. Most departments, like I said, have developed policies regarding social media. Smart and proactive social media policies help us as fire departments in avoiding the increased liability. Technology can be a very valuable tool, but it also can provide some problem spots for us. Information placed on social media sites may violate privacy concerns or portray departments in an illegal or otherwise negative manner. As always, we have First Amendment concerns when we draft and look at social media policies. The other thing could be HIPAA and medical confidentiality, even pictures posted of a car accident, for an example. And even if it does not have a tag number, simply knowing that somebody drives a car like that could set you up for liability. And it's just good policy not to be posting pictures like that on social media. Privacy rights of your employees and citizens, collective bargaining rights, and the right to engage in concerted activities. Copyright laws is another one. If there are images that are copyrighted or you're not the photographer and you snag the photograph and you repost, could set you up for a copyright law violation. As simple as using PowerPoints and using photographs off the internet or other clip art, you need to cite and get permission for all that use so you're not in violation of copyright laws. The law is intended to restrict photo taking and dissemination by emergency personnel at the incident scenes. Let's put it this way, there are simply some things that don't need to be seen and put out on social media. Again, one of the most common ones that come to mind is the car accident, where it may be easily for somebody to discern that that was, in fact, a wreck that one of their loved ones were in. The policy prohibits the posting or sharing of photos or videos taken on duty. Uh, some departments in some cities will have a policy that any photograph that you take on duty, on scenes and whatnot, has to be posted uh, to a server, and from that server, that it can be looked at by the appropriate staff and decisions being made on whether they can be put out. Same thing with your videos. And one thing to note again, you've got to be careful what you're posting again, because once you send it out there, you're reaching a lot of people and you don't realize it, but you can reach easily up to 6,000 people very quickly by one simple post. And this can happen within a matter of, minutes. So we strongly caution against, but not explicitly prohibit, posting disparaging remarks about the fire department. Basically, you think about it in the way that oftentimes we say and we post things in anger, or we have a disappointment about whether it be our employer, uh, or a certain person that we work for, this, that, and the other. And those are the remarks that you want to think about it. It's kind of like I tell people that when you draft an email in anger, don't send it. Put it in draft, come back the next day or 2 days later and read it, and I promise you, chances are you're not going to send that email. You're either going to delete it or it's going to be completely different what comes out after a couple days of cooling off. Again, it's not permitted to restrict firefighters' use of social media to discuss their employment. Enforcement of the social media policy. Instructors should emphasize to students that the importance of adhering to the established policies. In some departments, failure to adhere to the social media policies carries severe disciplinary action, up to and including termination of employment. Yes, it may be freedom of speech, but yes, you might be fired for it. That's the things that we got to remember. Copyright Act of 1976. This basically prohibits copyright, or protects, copyright of many training materials. It governs copyright issue, and then it divides work into two categories: those protected by law and those considered part of public domain. So when we build, as instructors, when we build a PowerPoint and we get on the internet, and the internet's a wonderful thing, and we start grabbing pictures and we start grabbing clip art that we Googled, and we can copy that clip. Two things: we need to get permission to use that in your presentation, and you need to cite that within the slide presentation. And it is also a good idea to have a citation slide at the end of your program that basically cites everybody that gave you permission to place their content, whatever that may be, in your presentation. Time frames for the copyrighted material published between 1923, public domain. If it's between 1923 and 1978, 95-year protection from the date of publication. Published after 1977, the copyright for life plus 70 years. Violation of the law can result in liability. Using copyrighted materials in training. Many training handouts are from copyrighted materials. The Copyright Act does not prohibit their use outright or require that permission be sought before they are used. So there is a fair use exception, basically. So like with these materials that we get from, whether it be Pearson, Jones and Bartlett, Fire Engineering, or IFSTA, when we buy that package, then we are buying with it that fair use exception. There are handouts and quizzes, copies of that stuff that we can hand out on paper, that we can utilize on the internet through Blackboard and things like that. It is perfectly acceptable to use in that fashion. The fair use goes to the training copies, generally fall into this category. Certainly the author and the vendors do not want you copying their entire textbook and handing it out. In the event to only buy one textbook, say for an audience of 12 or 15, that certainly doesn't fall under fair use. But it depends on the nature of the copyrighted work and how much of the work is copied. So a lot of the authors and vendors will allow you to only copy a percentage of, like a text, 10% or less, as an example. If a particular use is not fair use, then contact the copyright holder and seek written permission. When you're seeking permission, you really need written permission to do so. We've used and asked for a known cartoonist in the fire service, drawn by fire, and that that author gave us permission, written permission, to use the material so as we did not copy it and we did not profit from any of his artwork. And this is the same one that puts out this artwork you see it on the internet, you see it in text, he prints books of it, and people buy in all kinds of different avenues to view it and get it. Ethical considerations, considered in all aspects of your job as an instructor. We need to include those dictated by the fire department, and also personal ethics need to be included. Um, Reinforce ethical standards. Ensure that the department has clear standards, act as a role model, and place education above all but safety. Remember, safety comes first always. And one of the things you could ask some questions about: how would this look on TV? How would this look on the 6 o'clock news if it hit the news? What would your mother think about it, or your parents think about it? To ask those questions before you post things on social media, before we, use uh, restricted material. Records, reports, and confidentiality. We need to be thorough in our record keeping, accurate in our record keeping. This is all vital. And remember, when it comes to training, some of our record keeping could be tied to money, and we're talking about thousands of dollars. If you lie on a training form, if you lie about somebody being there so they can get credit, you could be ultimately committing a higher crime because it's connected to money. Document what occurred, document who was present, and document what each person observed. For claims of sexual harassment, document what was said, document what actions were taken. Record and record keeping comes with we need to store records, use organized, secure setting to store the records. Both state and federal laws prohibit disclosure of certain information. And so the department may have also policies and procedures in place that requires protection of personal information. The failure to abide by the law or the department policies on this could lead to liability or even adverse actions. So we want to protect personal information. That's why on a lot of your rosters, we no longer use Social Security numbers. The state of Kentucky enacted firefighter numbers many years ago in order to eliminate this. And that way you can't get a hold of someone else's personal information, such as a Social Security number, just from a training roster and record. Keep these records secure and confidential. These include personnel files, files that are used and maintained throughout the hiring process, and any disciplinary files. The disciplinary action, the files and files that pertain should all be kept confidential. If someone else finds out about someone's disciplinary action, whether they got suspended or they got written up, the only person that should come from is the person that it happened to. If they're going out there and talking about it amongst their peers, that's on them and that's their business. But it shouldn't come from us. Audit record keeping systems, a yearly system to identify any inaccuracies, and then to maximize our efficiency with our record keeping. Record keeping is a part of risk management. Keep for 5 years after training. Sign-in sheets you want to keep for 5 years. The training topic that was permitted. Any handouts, records, reports, or memorabilia, memorandums, for any unusual occurrences. So these should be kept with the training sheet. A lot of these training sheets have information on the back that you can document all this. I usually attach any other reports or records or a copy of it with it. That stays in the file. Incomplete, missing records make defending suits much more difficult. Risk management incorporated into all aspects of the job, which we do, and we should. Focus on minimizing risk. Ensure training is completed on all pieces of apparatus and equipment. Provide the training related to fire suppression tactics and EMS standards. Again, we are following the standard. Non-operational training and duties of the instructors. We educate all members of the department about the law. We're going to do the education on hostile work environment, any of those claims, sexual harassment claims. This is a training that we should be doing annually on a regular basis. And then maintain up-to-date policies and procedures. Provide training on all policies and procedures. When a new policy comes out and is put into play, then there should be training on these policies. Review all areas to eliminate potential risks. Staying up to date. Remember that changes in the fire service are occurring constantly. Modify training, presentation, or policies so that they reflect the latest of the latest news, latest laws, latest standards as well. Fire service instructors oftentimes simulate dangerous situations, creating the risk of injury or even death. As instructors, we may be found civilly liable for negligence or possibly charged criminally if he or she does not fulfill the necessary duty of care to the trainees. The employer or agency can be held vicariously liable. Oftentimes, this comes to play when we talk about live fire training evolutions. This is the reason why we have the NFPA standard 1403 and that we adhere to it. And that's just one example. Firefighting is a dangerous job. Oftentimes we train real job and real world and to get that experience, and we do things nearly the real world scenario. And this is where we have to minimize that risk as much as possible, if not completely, while we train. Civil liability may occur if the instructor owed a duty of care to the injured party, and the instructor then breached the duty of care, and then the breach has caused an injury. So duty to act, a breach of that duty, and then that because of that causation, there was an injury. Criminal liability may be proved if gross deviation from the standard of care occurs, such as actions that are intentional or reckless, and a criminal statute exists under which the local state or federal prosecuting attorney can file charges. Jail time results if guilt is proved beyond a reasonable doubt. Don't think that if you do things and you deviate from things and bad things happen, don't think that you can't go to jail because you're in the fire department. Employer or agency liability. The instructor's employer or agency can also be held vicariously liable. An example of civil liability or negligence can arise for both the employer and agency and the instructor if an instructor fails to train students properly during the rescue training exercise that results in the injury of a participating student. Again, we have to reduce risk as much as possible. We're not going to do the two case studies today, but we are going to sum up what we've talked about. Every training session exposes the fire service instructor and the department to potential liability. Laws are established either through the legislative process in statutes or at the administrative or local level with regulations and or codes. Our instructor conduct is governed by three sources of law: federal, state, and your fire department's policies and procedures. Documentation and record keeping are essential to protect yourself and your fire department in case of a lawsuit. Federal employment laws, such as the Americans with Disabilities Act, the Civil Rights Act of 1964, and the Title VII of Civil Rights Act. The Employment Opportunity Commission is charged with investigating and enforcing federal workplace discrimination laws. Negligence, misfeasance, is unintentional conduct. Malfeasance is conduct that includes an element of intent or a knowledge that a wrong is being committed. Some materials that you may want to use in training are protected by copyright laws. Social media usage brings potential liability. Again, oftentimes when we do live fire training, we ask students, do not take any videos, do not take any pictures and post on social media. Many of the social media policies prohibit the posting or the sharing of these photos and videos gathered while completing not only department training, but fire department business. Ethical conduct should be the goal for everyone involved in the fire service. Lawsuits evolve over long periods of time, which means that the thoroughness and accuracy of your records is vital. A vital function of the fire service instructor is to minimize risk.